Hello, everybody. Daniel Gaines here. Time to go over my declarations. I apologize for the lateness of this video. I know I was already supposed to have it done, but I've been working diligently getting my case law together for the legal action I'm taking. I've got more than 50 pages of case law, more than 200 cases. So I've been busy, but I still should have already had this done. I do apologize. I'm going to be going over two of the three tonight. The third one I'll do tomorrow night. I give my word, tomorrow it will be uploaded. And with the one tomorrow, I'll have a few other documents to go with it. That's why I'm leaving one of them off tonight. Plus, this video is probably already gonna be have to be split into two because of the length of time. Because yeah, let's just get going. You'll understand. All right. Received and filed, Mason County, Washington, July 6, 2015, 10:05 a.m. Okay. Keep that in mind because if you remember from whenever I showed Juliette's declarations, she filed one on July 6th as well towards the end of the day. Okay? Which is why the second one of mine is the very next day. Straight up. Two different declarations filed the very next one day apart due to Juliette filing a document on the 6th in response to this at the last minute. But let's get into this. After all this BS, sorry there's a fly buzzing around in my basement. I don't know how in the hell it got in my basement, but if you see it, I apologize. It is annoying. But anyway, after all this, she says, I didn't highlight this. It says, I have reviewed the motion that Ms. Parker submitted requesting that my visitation be denied under RCW 26.09.260, Part 8, Section 8. And it basically states that if you voluntarily don't visit your sons or daughters within for a year, then that's what that is, basically. It says, it is my understanding that this particular statute requires that I voluntarily refuse to see our daughter. There has been nothing voluntary about my lack of contact. Ms. Parker has attempted to get restraining orders to prevent any contact with our daughter. Ms. Parker's declarations in support of the protection orders have gotten more and more unfounded and ridiculous. In 2004, Ms. Parker only claimed that I grabbed a phone from her, failing to mention that I supposedly threw her down the stairs. The claim that I threw her down the stairs did not appear until the Oklahoma restraining order. The allegation that I bit our daughter did not appear until 2009. Ms. Parker claims that she knew I was doing meth in 2009. However, not once mentioned that concern in 2009 during the Monterey court hearings in Monterey County, California. Ms. Parker moved and changed her phone number in 2009 and cut off all contact between me and our daughter, despite a court order requiring phone calls. At that time, our daughter was 5 years old. Ms. Parker's actions have been deliberate and aimed to alienate our daughter from me. In this, she may have succeeded. It's gotten worse over the last 5 years compared to then, but I'm still hopeful. I'll always have hope, and at the end of the day, she's always going to be my daughter, so I'm always going to love her no matter what. It doesn't matter. How I feel about her and as much as I care about her and everything else will never change. But anyway, says, I have tried to call and talk to our daughter every Sunday since I got Miss Parker's new phone number. Miss Parker has either refused to answer the phone or answered and told me that our daughter was not home. Miss Parker has gone out of her way to ensure that I have zero access to our daughter. Miss Parker claims to have gone to Texas in 2009 due to a difficult pregnancy. However, her attorney at the time submitted a letter to the court stating that she went to New Mexico. Miss Parker claims she moved to Texas to be near her father, who is a pediatric GI, not an OBGYN, who at the time was only licensed to practice medicine in the state of New Mexico according to his medical license. Miss Parker had stated under oath that she went to Texas, but the proof shows she went to New Mexico, based off of her own comments. Miss Parker claims that she went to Texas when she got in the legal trouble to help her mother, who had a stroke. However, according to James M. Noel's Facebook page, Carol did not have her stroke until October of 2014, not June of 2014. Further, the address that was given to police by Cody Hyman, Juliette's live-in boyfriend, Miss Parker and him moved to his parents' house, which is 2.5 hours away from where Miss Parker's parents live. Miss Parker flees the state anytime court actions are going against her. Miss Parker claims that there was domestic violence, which is the reason she will not let me be a part of our daughter's life. However, none of the alleged abuse was ever documented, nor does the timeline she gives under oath match the documents she has filed. Miss Parker claims I threw her down the stairs while she was pregnant with our daughter. However, during the first restraining order, that was not mentioned. The bite mark I allegedly left on our daughter's arm wasn't mentioned until 2009. Miss Parker filed a restraining order in 2005 after the supposed diaper rash and biting incident, but neither of them were listed until 2009. Now she claims I'm on drugs. After 6 years of avoiding me, she claims to know something about my life. This is the first time she has claimed drug use in any court. Miss Parker claims that I was intoxicated at our daughter's 4th birthday party and violent towards her. However, I did not go to the party and I did not drink the whole time I was in Texas. There was no way that I would ever show up to be around my child under the influence of anything. This is the first time that Miss Parker has ever claimed that I was intoxicated at our daughter's 4th birthday party. Miss Parker did not even make that claim on the 20th of May during the restraining order hearing. This is also the first time she has asked about classes of any kind. Pardon me. It is also the first time she has tried to further restrict my access to our child. That is a typo, and I actually never noticed it until I was highlighting. It is supposed to be this is not the first time. My attorney at the time was supposed to proofread all this and everything else, and is what she ended up actually doing was copying and pasting directly. So, yeah, it's kind of rough and ugly in spots, but that actually is a typo. In 2009, she actually tried to restrict my access, and it ended up not going so well for her, which is why she ended up fleeing the state. Blah, blah, blah. For that part, get down here. Miss Parker's actions since she filed the petition for the domestic violence protection order on May 5th, 2015, demonstrate a clear lack of fear of me. Since the day after the restraining order was filed by Miss Parker, I have received numerous texts from her asking me to just leave our daughter alone and stay out of her life. Miss Parker has been harassing me nonstop since early May. On July 4th, 2015, Miss Parker texted me by accident, and I just responded that she sent the text to the wrong number. From that moment, Miss Parker sent text after text harassing me about this hearing, demanding to know if I was going to be there, asking me not to go. Every time she receives documents that my attorney has submitted, Miss Parker texts over and over mocking me and telling me that she is going to win and I should just give up. The problem here is that there is no winning or losing. It is in our daughter's best interest to have a relationship with both of her parents. Miss Parker has spent years destroying my relationship with our daughter. I have not been able to speak with our daughter since she was 5. The only reason our daughter considers Skip her father is because Miss Parker has barred me from having any contact with our daughter. Skip is Robert Parker's, what they call him. I don't know if they still do. I imagine that they would, but Juliette's husband, Robert Parker, is who Skip is. But let's keep going. All of the evidence I have submitted shows that Miss Parker has purposely worked to alienate our daughter from me. I hope that the courts look at the evidence for the value of all the documents and make the right decision. It is clear based on all the things Miss Parker has filed and stated under oath that her story changes with each retelling in order to get what she wants. I can prove that with 4 sentences and nothing more. Look at the transcript from the restraining order hearing, then read my declaration that was filed after that. It states several different changes to her story, which shows that she is making this up as she goes. My claims have not changed at all, not even in the slightest way. The letter from CPS that Miss Parker submitted stated that their experts stated that there is no way that the explosion at Miss Parker's house could have happened the way that she claimed. It does state that the police reports are wrong. However, that would be true if it was an actual 20 millimeter round. If it was a 20 millimeter training round that exploded in the home, and that is the difference. It is supposed to say if it was a 20 millimeter training round that exploded in the home, that would be what makes the difference. But again, my attorney was supposed to proofread and didn't. Anyway, however, it does state that her story is false and incorrect. All of these things together show her willingness to try anything to keep my daughter from me. Ms. Parker claims that her father has had the same number since 2008, which cannot be true because he moved from New Mexico to Texas sometime in 2013, according to his medical license. When I called the office he worked at in New Mexico, I was told they never heard of James M. Noel. Ms. Parker claims to have had a business and other publications, but offer no proof that any of these things actually exist. I am objecting to Ms. Parker's request that I pay all her attorney fees. If it were not for her actions, we would not be in front of this court. I am respectfully requesting that this court find that there is adequate cause to modify the parenting plan and allow more time. I am requesting that Ms. Parker's motion to modify and cut off all contact between me and our daughter be denied. That's the end of that one. Now let's go on to again, this was filed on July 6th, 2015 at 10:05 a.m. Her attorney and her ended up filing an amended declaration to her first one because I called out some of the lies in it. Go look at the video where I go over her declarations. You'll see. She put some crap lies in her declaration. I proved it was lies. She amended it at the last minute. So then the next day, whenever my attorney got the document, she got it to me. I had to type up a response, and this is the response to her amended declaration. As you see, the date, time, case number, declaration of Daniel Gaines, and strict reply. Pardon me. In the documents that Ms. Parker has filed, first and foremost, these documents were not submitted to the court or us in a timely manner. I have never voluntarily removed myself from our daughter's life. I was not involved in her life because I have not been allowed to be. Ms. Parker has done everything in her power to keep our daughter from me, including, but not limited to, filing numerous restraining orders, fleeing the state anytime actions are brought against her, etc. I have never exercised to see my child for a couple of reasons. One reason is due to the insane amount of child support I am ordered to pay. I could not afford it. Second is because I have not been aware of where my child is located at. Juliette would not answer my calls, nor would she give me an address or even a state she was in. She has lied numerous times about where she has gone with my child. The documents submitted by my attorney prove that. She claims to have had the same number until 2013, but shows no proof of that actually being true. All she submitted was an email stating that she can get a lower rate. I get these same emails on a regular basis. If Ms. Parker truly had not interfered with my right to see our child, then why would she have sent our daughter to Texas on May 5th, 2015? Ms. Parker sent our daughter to Texas 4 days after I told Ms. Parker's father that I was going to seek custody, and the same day that she filed for a domestic violence restraining order. Ms. Parker took her daughter out of school a little over a month before school was out. Ms. Parker never informed this court until now that our daughter was in Texas. Ms. Parker has been disingenuous with this court since she filed for a domestic violence protection order. Ms. Parker is now claiming that our daughter being in Texas does not interfere with me seeing our daughter. Since Ms. Parker is completely opposed to my seeing our daughter, of course her being in Texas interferes with my seeing her. Further, Ms. Parker has filed a notice of relocation after making numerous statements that she has never tried to avoid court actions. Ms. Parker sent our daughter to Texas in hopes of preventing contact between me and her. Ms. Parker claims to be in financial need and wants me to pay her attorney fees. I should not have to pay her fees due to the fact that none of this would be necessary if she had allowed me to be a part of our child's life. Ms. Parker should have to pay my attorney fees for the same reason. None of this would be necessary if she had not kept my child from me. In 2004, I did know her address. I stopped getting that information after she left the state of Oklahoma in 2005. The document that she claims I signed has a few issues with it. One, that the signature looks nothing like my signature. Another is that this document also states she was to give me joint custody. Why would she be willing to do that if I was such a danger? The problem, though, that I ended up finding out after I got the copies from the courthouse was that the one that my attorney sent me was a bad copy of it, so it was all jacked up. You could hardly read anything that was on it and everything else. So that's all I had to go off of until I actually got the document from the court but I didn't realize what I had hired in Sarah Whitney. I fully understand that now, and I'm much more cautious now. I'm also much more knowledgeable than I was 5 years ago. But yeah, that's my fault for not doing enough research into the attorney that I was giving money to. Anyway, also, I was not in the state of Texas on the date that this document was signed. In Miss Parker's amended declaration, it states that she was foolish to try and dismantle the ammunition. However, in Miss Parker's initial declaration, did not admit that they were doing that, and in fact denied that even being true. However, the police reports all state the same thing. It happened in the room above where the children, not child, were sleeping in. The probable cause statement also states that they had been doing it for a year. My claims are all true and all the evidence supports this statement, which it does. In Miss Parker's amended declaration, she states that after the incident, she moved to Mr. Hyman, which is Cody Hyman, her boyfriend, Mr. Hyman's parents' home. In Miss Parker's original declaration, she stated that she moved to Texas to help with the care of her mother who had a stroke. Miss Parker's mother did not suffer a stroke until October of 2014. Miss Parker's story changing serves to prove that she fled to avoid prosecution just as she does each time I have tried to get rights to my child. Again, Miss Parker claims that I have been abusive to her and our daughter. However, the documents that she claims I signed to terminate my rights is saying in return I get joint custody. Again, why would she be willing to give me joint custody at any time if I was a danger? Ms. Parker claims I have proof that she sent me letters with their address changes on them. However, she cannot provide any receipts of these letters that these letters ever existed. Ms. Parker cannot show anything other than serial numbers that when looked up say they are invalid. Ms. Parker claims to not have receipts because moving. However, at the same time, she claimed on May 20th, 2015 that I supposedly threw her down the stairs when she was pregnant and as a result went to the hospital. That was all in her restraining order that she filed. At the hearing, she did not mention going to the hospital and even said that she did not when the judge asked her. She then stated, after my attorney asked, that she did go to the hospital but could not get the records because they were destroyed in Hurricane Katrina. She later stated that she did go to the hospital 2 weeks later. The point of this is to illustrate that she claims many different things but cannot ever show proof for some reason or another. Ms. Parker claims I have thought I was dead due to drug use. However, Ms. Parker has never stated on any court document in any court that I have ever used drugs until this recent stuff in 2015 started. There has been no contact in 6 years. If she never claimed I was on drugs before, how can she claim that now when she has had no contact with me and knows nothing about my life? It is easy to make allegations hoping that this court will order a bunch of services just in case her allegations are true. Ms. Parker's allegations are not true and have never been true. Ms. Parker makes allegations specifically geared to prevent or restrict my time with our daughter. Again, I have not exercised my right to see our daughter because I did not know where my child was at, nor have I known since she left the state of Oklahoma in 2005, with one exception being when she was in court in California. And then, well, obviously outside of her 4th birthday, which had already been stated that I had seen her. Even then, I did not know that she had left the state until her attorney told the judge late into the proceedings, which was after she was gone. Ms. Parker claimed on her original declaration that she went to Texas to be with her father because of a problematic pregnancy. At the same time, she was filing documents in the state of Washington, while her attorney at that time filed a document with the courts in California stating that she went to New Mexico to be with her father. His medical license was only active in New Mexico during that time frame. She claims to not have changed her phone number that is, until 2013. That is a lie. I did try to contact her, and in late 2010 or early 2011, the number was no longer a working number. Her service provider for the number I had was Sprint. She keeps claiming that she sent me certified letters to inform me of her numerous address changes. However, if that was the case, how could she have sent them to my address when the address she would have sent them to, the house was destroyed a few years ago? My family moved out of that house in 2010. I was unaware of her even going to Texas last year, and I have been at this address since April of 2013. That was at the Fenton address I lived at that time. In regards to Ms. Parker's claim about my supposed dishonorable discharge from the military, her story is different from her testimony in the DV protection order hearing till now. In her original declaration, it was for drug use. Now it was for alcohol use and other things. In the restraining order hearing that I showed on the video, she stated that it was because I assaulted a superior officer. So again, in 2 months, 3 different versions. The documents provided do not show anything about a court martial or anything about what that case was about. All it shows is my name. In regards to the supposed bite mark, Miss Parker now claims that when I bit our daughter, she cried. However, that supposed bite I gave our daughter was not mentioned in the restraining order filed in 2005 and was not mentioned until 2009. And now, along with all the other threats I supposedly made, which are false, however, she is now claiming that I threatened to break into her home and stomp on her head until no more blood comes out and take our daughter. This is the first time, I believe, she has claimed that I threatened to break in her home. She claims that I sent her an email threatening to break her jaw because she filed a restraining order. However, in her statement under oath, she claimed that I sent this email to her 3 days before she ever filed a restraining order in California. So now, to add to her many other claims, I am also able to read the minds of those halfway across the country, which is basically the way it went. She said that, basically it was implied that I could read her mind halfway across the country. She claims I was intoxicated at our daughter's 4th birthday party. I was not allowed to attend the party at all because I was forced to tell Juliette that it bothered me that her daughter was forced to sleep on the floor the night of her 4th birthday, all because she was hungry and did not want to go to bed. Again, this is the first time she ever stated that I was intoxicated. It has never been mentioned before during any court hearing, nor has it ever been mentioned on any court document. This further proves my claim, along with the numerous other inconsistencies, that she will do and say whatever she feels she needs to do or say to keep my child from me. Ms. Parker claims that me having contact with our daughter will be harmful to her because of my history of drug use. Again, this is the first time any mention of drugs has ever been mentioned. She also claims that I am an aggressive person. However, every person that knows me will tell you something very different than that. Everyone who knows me to always have a smile on my face and to be a kind and gentle person, as well as the fact that I have no record of any violence at any point in my life, nor has anyone but Juliette ever claimed that I was violent. Ms. Parker also claims that she should not be allowed to be that I should not be allowed to be any part of any decision making because that decisions cannot be made in a timely manner. However, she has my number, and I am available at most times, so any decision could be made in a matter of minutes with proper communication between myself and Juliette. However, Ms. Parker refuses to tell me anything, so therefore I have not been a part of any decisions that have been made. The email she submitted does not show that she changed her number from the one I had in 2013. It shows an email like the ones I receive on a regular basis. It does not show when her number changed. Again, the document she submits does not show the information she is claiming them to show. Yes, I do owe back child support. However, at the time that it was started, she claimed I was bringing home more than $2,000 a month at a time when the minimum wage in the state I was living in, Illinois, was only $5.15 an hour. It was always more than I made and set higher than the law allows for the amount I made soon after that. Ms. Parker also submitted a document showing that my daughter went to Texas May 5th. She was pulled out of school over a month early for this. Also, during this time she was in Texas, Juliette was given a temporary restraining order ordering her to keep our daughter in the state of Washington. Our daughter was in Texas at this time and has been there since. Ms. Parker never informed anyone that our daughter was in Texas. This shows her clear lack of concern over court orders and her willingness to violate any court order, just like she did in 2009. Ms. Parker submitted documents to the courts from things she filed in 2009 in the state of Washington during the time the matter was being handled in the state of California. These documents were never served to me, nor did I know about these documents until May of this year. According to the documents filed by Ms. Parker, she stopped child support in 2009 in the state of Washington, only to have it started again in a different state in 2011. How can she go from state to state doing things when Washington had jurisdiction at that time? Many of the documents Juliette have filed have no relevance to what's going on. If her intention is to prove that I could have found her, then that is false. I am not technologically inclined. I would not have been able to find that information. At the same time, she is claiming that I could have used that information to find her, but yet my fiancé found her father's information along with all the other numbers I have called. Ms. Parker tried to claim that I was stalking her because of the method I was forced to use to try and locate her. If I try to find her by the information online, she files restraining orders claiming I am stalking her. I cannot call the schools to find out if my child is registered in any specific school due to federal laws prohibiting schools from giving any information about a student. According to her document, she has moved more times than the tracking numbers she shows. She supposedly sent me addresses that she had submitted to the courts. Again, pardon me. In June 2015, I informed Juliette that I knew where my daughter lived. She started saying, "Do not show up at her home or her school." It was today that I received a letter from her saying that she is planning on relocating my child to Texas. Ms. Parker claims to have not changed her number until 2013, but has no proof that she changed it then, as well as all the information she has provided. Not one piece of this is later than 2011. On July 6, 2015, Juliette and I had a phone conversation that lasted almost an hour. During this time, she stated several changes to her story, many of which have been changed in her amended declaration. Other things where her story has changed have been mentioned in my other documents. The conversation was recorded by myself and Ms. Parker, and both of us have agreed that the conversation can be used in court if allowed by the courts. I am working on getting the recording transcribed and will have it submitted once that is complete. One of the things that Ms. Parker stated in her conversation was, "I haven't given you my physical address because you don't need to know that." Ms. Parker also stated, "Yep, I went to Texas. I went to New Mexico on my way to Texas because my parents lived there." That was in regards to her declaration stating that she went to Texas in 2009 to be with her parents so her father could look after her during her difficult pregnancy. During the conversation, I asked her in 2009, "How many years have you been back in Washington?" She stated, "Why does it matter?" When asked several more times, she finally responded with several years. This comment was stressed by Ms. Parker. She goes on to state that, "I have your signature on the first one of those receipts, so I know damn well you got them." That comment was made in the reference to the certified mail she sent me with the address changes, the same receipt that she claims to have lost due to all of her moves in her original declaration and her revised declaration. During our conversation, I stated that Juliette and one of her ex-husbands flew to St. Louis to pick up our daughter from me in 2005. This happened before she filed the restraining order in Oklahoma in 2005. I mentioned that she left a lot of stuff off that she claimed happened, and she stated yes, and that would be because the police officer told me not to include 20 pages worth of crap. Then stated they said to put what occurred within the past 30 days that happened. The diaper rash incident happened the same day that she took our daughter home from Illinois, supposedly. According to her timeline events, that should have been included and was not. Her story changes with each retelling. The conversation went on that after that, Ms. Parker stated that I have information from the provider that I had that number until 2013. That was in regards to her number change. I'm trying to keep this in one video, so I'm going to try and speed ahead. The conversation continued. She goes on to say, "You didn't call in for any of that, Daniel. This is during our discussion about why the judge was getting stricter with her during that time. She claimed over the phone today that I did not call into any of the court hearings." Ms. Parker stated that one document in the beginning states that because I was in the middle of moving, she couldn't get a hold of me while we was crossing country. This is in regards to the letter from her attorney in 2009. The pleading we were discussing was the one where her attorney stated that she could not get any documents from Juliette because she moved to New Mexico to be with her father so he could look after her during her pregnancy with her son. The date on this document proves that it was towards the end of the California hearings, not the beginning. It was brought up that her story changed when compared to her original declaration. During our conversation, I mentioned that our daughter's birth certificate was destroyed in Katrina. She even stated that during our conversation, she later said that they recreated it from her hospital records. How can that have happened? How can they recreated our daughter's birth certificate from hospital records when she just said that it was all destroyed by Katrina? It was brought up because I asked who was listed as a father on her birth certificate, because on the original, I was listed as the father. I would like the courts to order that Juliette submit a copy of our daughter's birth certificate to confirm what it states, since I have shown more inconsistencies than I care to count in just this document alone. However, once added to all the other documents, the number of inconsistencies in her story is truly staggering. And again, that's the end of this one. I do have one more. As you see, it's not highlighted. It's several pages long. 6, actually. That'll be posted tomorrow. I'll have a couple other documents with this. One will be the CPS letter from 2015, and then the other one will be the probable cause statement from Tacoma Police Department about the 2014 arrest and that incident. Thank you all for taking the time to watch this. I appreciate each and every one of you that are doing so. I love you all more than you can ever understand. It's truly greatly appreciated, and thank you very much. Again, please watch and share. Let's help get the word out. Let's help in the abuse of my rights. And let's hopefully, bring change to a broken system. Again, thank y'all and have a wonderful night. Bye.